I am Isabelle Huys from the Faculty of Pharmaceutical Sciences at the Catholic University of Leuven and specialized in intellectual property rights and regulatory sciences. We will talk in this session about intellectual property rights and their role in several sectors such as the pharmaceutical sector, but also the engineering and the humanities domains. I will first give you an overview of diverse types of intellectual property rights and more specifically the patents. We will see different characteristics of these patents and where you can find patents. And at the end, we will also see what you can do with intellectual property rights in terms of exploitation. Intellectual property rights. Suppose you are the discoverer and developer of a medicinal product. What you then want is that those patients get access to your technology. On the other hand, you want to get a return on your financial investments that you have made in order to make this medicinal product. And this is the type or the place where intellectual property rights play a role. These intellectual property rights protect intellectual property, which are the intangible assets that are embedded in the tangible products, for instance, your medicinal product in this case. And it is this concept of intellectual property rights that we will discuss today. Here you see a mobile phone, which covers several types of intellectual property rights. For instance, the trademarks. Trademarks are, for instance, the Nokia that link this particular logo to this product and that link this product to a particular source or firm that makes this particular product. Another type of intellectual property rights are patents, which protect technical inventions that are embedded in this product, for instance, this mobile phone. And these inventions are, for instance, chemical products or the data processing methods that are underlying this product. Other types of intellectual property rights are copyrights, for instance, the software code or the instruction manual, and design rights. Design rights protect the form or the shape of this particular mobile phone. Not all inventions or not all aspects of particular products are protected by intellectual property rights. You can also keep certain aspects secret. And the way you can get these intellectual property rights differs also across these different types of intellectual property rights. For instance, for a patent, you need to file a complete dossier of your invention that is then afterwards assessed by particular experts at the patent offices. On the other hand, copyrights occur actually automatically the moment that you create your original expression of your idea. We will focus now more on patents, because these patents play a particular role in the technical context, for instance, for pharmaceuticals or for the engineering context. What is a patent? In fact, a patent, you need to look at it as a social contract between the applicant and the government. And the deal that is concluded is about the fact that the applicant needs to disclose his invention as much as possible, and in return he gets an exclusive right. This disclosure is meant that others can learn from his invention, can actually improve his invention, and also to avoid secrecy. The exclusive right that the patent applicant then receives is actually a right that he receives to exclude others, third parties, from using his invention without his consent, to commercialize it, to sell it, to make it, to offer it for sale for others without his consent. He can have this exclusive right for a period of 20 years from the moment that he applies for this right, and only in a particular territorium, so only in a particular country. Does this mean that nobody can use his invention? No. There is a concept, namely a license agreement, wherein you can conclude with the third parties on which terms access to this underlying invention protected by the patent can occur. How do patents look like? An introduction, a description, and also designs or drawings. However, the most important part in a patent document are the claims. Those are the wordings that exactly protect what is the invention and that actually determine the scope of your patent. How can we get a patent? In order to receive a patent, it will be assessed. And this assessment means that the patent will be tested according to different criteria. First, you need to have an invention. And if you have an invention, this invention needs to be technical and it needs to be new and include an inventive step over the prior art. In addition, it needs to be susceptible for industrial application. And, as was concluded in our deal, this invention needs to be sufficiently clear and completely disclosed. Where can we apply for a patent? You can apply for a patent at a national or at a European level. For a national patent, you need to go to the national patent authorities. For a European patent, you go to the European Patent Office. And the moment at the European Patent Office that your patent is granted, it falls apart in different national patents. And when a party makes infringement of your patents, then this will be dealt at national patent courts. In the near future, there will be a union patent, where instead of these different national patent courts, a unified patent litigation court will be installed. Where can we find patents? There are several databases where patent documents are listed in. You have free patent databases, and you have also commercial patent databases that contain information of thousands of different inventions, technical inventions. One example of a patent database is the ESPASnet database, which is a free, accessible patent database where you can, by introducing keywords or, for instance, international classification numbers, where you can find these inventions by using these keywords and international classification numbers. Having a patent is one thing. However, exploiting your patent or exploiting intellectual property rights is another thing. Suppose we have here a particular project that needs to be carried out. Where are intellectual property rights important? Actually, they are already important at the very early start of your project, namely at the planning phase, at the moment that you plan your project. There it is good that you start your patent search in order to look at what is already in the field, what has already been protected. As you know that patents can only be granted for inventions that are new, it is necessary that you guarantee the novelty of your invention. And that's why confidentiality agreements in several cases are concluded very early at the start of your project. The moment that you get a breakthrough or a novel invention within your project, then it is necessary to think about what type of intellectual property rights might play a role or might be interesting for our project. Patents, maybe trademarks or software protection. And a bit later on, when you go commercial, it is also necessary that you carry out a freedom to operate search, that you guarantee that you are not infringing other one's rights. In case you go international, it might be interesting to adapt your IP strategy and maybe to think of licensing to others. And indeed to look at who else enters the market, because this is what patents do. They exclude others from entering the market without your consent, but it is up to you to monitor your rights and maybe to enforce also your rights. Patents grant the owner indeed the right to prevent third parties from making, using and offering for sale the products or the processes that are protected by these patents. However, how does this then goes in collaborative projects where different parties need to collaborate, where different parties need to have access to the different types of inventions that reside with these different parties? In that case, a consortium agreement is concluded. An agreement that contains particular clauses on intellectual property rights and also on access to these intellectual property rights, on access to these patents for the different parties within the consortium, but also for third parties outside the consortium. So what are the takeaway points from this session? It is really important that in terms of intellectual property rights you take into account and you try to balance the interests of the private and the public sector, and that you consider the advantages and the disadvantages and maybe the alternatives of patents. And only when this is the case, it is possible to create a stimulating environment where innovation can occur. Thank you.